Hey guys, welcome back to my channel, Down the Rabbit Hole News. I am the Rabbit. Listen, before we get into the Chad Bianco lawsuit, recently the Riverside County District Attorney's Office made a Facebook post several hours ago, and they basically said, "We understand how deeply the community and the media cares about baby Emmanuel and are eager for information about this case. We share your desire for justice and your desire for transparency. However, there's been significant amount of misinformation circulating in the media and on social media, which can be confusing and frustrating for everyone. Please note that we are committed to providing accurate information. Also, please understand that we are bound by legal and ethical responsibilities that prevent us from sharing detailed case information publicly." Okay, that I can understand, right? Like, these responsibilities are in place to avoid making statements that could influence the case, prejudice the fairness of the court proceedings, or impede the goal that we all share, justice for baby Emmanuel. We kindly ask for your patience and understanding, and to trust that accurate facts will be shared through appropriate official updates in due time. Spreading false information or rushing to conclusions can unintentionally hinder the investigation and impact the court proceedings, which are essential to receive justice. To receiving justice. Thank you for your understanding and cooperation. That was a statement that was made. And one of the things that I thought while the district attorney's office made that statement, I do wonder if they're even able to hold trial in that jurisdiction. And what I mean by that is, are they going to be asking for a change of venue, given that it seems like everybody has been part of, in that community, has been part of the search? Could there be an issue of prejudice in that community, right? Given that everybody's been involved in this conversation, in this case, this case has gotten so much national, international attention. I've had people email me from different areas of the world. But let me know what you guys think in the comments. Now, the next part of this video is about Mr. Chad Bianco, aka Yosemite Sam.
Yosemite Sam! It's Yosemite Sam! Yosemite, yeah, Yosemite Sam! The roughest, toughest he-man, stuffest hombre has ever crossed the Rio Grande.
I just want to thank all of you for, especially the normal mainstream media, not so much for social media and keyboard warriors who, quite honestly, sometimes hamper and prevent us from a good investigation.
So I was looking a little bit more into Chad Bianco, right? And kind of his background and stuff like that. And he's very much political agenda driven, which, I mean, that's his thing. He wants to run for governor. That's his thing. For the most part, he hangs out with various circles in the political realm, right? And he's well liked in those circles, specifically his agendas, his policing, his beliefs, and whatnot, which is okay. I guess that's completely up to everybody who likes Chad Bianco. But there is this other side where he has been sued before for defamation. Someone by the name of Van Miller sued him in Las Vegas and filed a 100 million federal lawsuit against Bianco in Riverside County. So Van Miller at the time had alleged violations with his constitutional rights, defamation, and intentional infliction of emotional distress. And it was pertaining to that Bianco tried to frame, or at least publicly portray, Van Miller as somebody having to do with the attempted taking out of Trump. Okay, so these are claims that Miller disputes, and so he did file a lawsuit in March 2025. Okay. But the lawsuit that we're about to talk about is very specific, and it's just that it's a lawsuit. It's a bunch of allegations. It does not mean that they are true. We are just reviewing this lawsuit, and any commentary that I give is just opinions. Just opinions, my opinions. Just like it's my opinion that, Chad Bianco kind of has a Yosemite Sam personality. It's just an opinion. So please take those allegations as opinions and not facts. These people will have their day in court to dispute what needs to be disputed and whatnot. All right, guys, let's go and review this. And let me know what you guys think in the comments. Support the channel. Let's go. Let's get into this lawsuit. Okay, this lawsuit was filed on July 7th of 2025, just this year. And this lawsuit was filed by someone named Victoria Flores, and she is suing Chad Bianco, the sheriff's Riverside County, Don Sharp, Under Sheriff Herman Lopez, Assistant Sheriff Corrections, County of Riverside, and Does 1 through 10 inclusive. Now, here are the complaints for damages on this civil lawsuit: retaliation in violation of the Federal False Claims Act, retaliation in violation of California False Claims Act, wrongful termination, whistleblower retaliation, wrongful termination and retaliation in violation of public policy, gender discrimination in violation of Fair Employment and Housing Act, conspiracy to interfere with civil rights, violation of civil rights. Okay. And violation of civil rights. Okay. Let's start with the intro. This action arises from the wrongful, retaliatory termination of Victoria Flores, a highly respected and principled sheriff's captain with an embellished record of integrity and professionalism over her decades of service to the Riverside County Sheriff's Office. Flores' unwavering commitment to honesty and accountability made her a target in a department plagued by corruption, unconstitutional conduct, and gender discrimination. Sheriff Chad Bianco and his leadership team sought to silence and discredit Captain Flores. Bianco used a minor incident at the shooting range as pretext for terminating Captain Flores to shield the department from scrutiny. Ooh, what is a minor incident at a shooting range? I hope this lawsuit explains that. Bianco intentionally stigmatized Captain Flores, impaired her reputation for honesty and morality, causing her great emotional harm, hindering her future employment opportunities. In holding defendants accountable for their unlawful actions, plaintiff seeks full and equitable relief. So, jurisdiction and venue, of course, this is where they feel like the lawsuit needs to happen. Just to double check, the United States District Court for the Central District of California. This is where they want this lawsuit. Okay, let's get into these parties, all right? And then we'll get to the allegations. Parties. Plaintiff Flores, at all relevant times, was an employee with Riverside County Sheriff's Office, the RCSO. She began her career with RCSO in 96 and served in the RCSO with pride and integrity for 28 years. Through her hard work and dedication to service, Flores overcame multiple roadblocks to move up the ranks in RCSO. From her beginnings as a correctional deputy through positions as corporal, sergeant, lieutenant, and finally achieving the status of a correctional captain at the Robert Presley Detention Center, a position of great responsibility, which she held until the time she was inappropriately terminated. Now, Robert Presley, I believe, is the detention center that Rebecca Haro is at, okay? Over the course of her career, Flores managed large departmental projects, chaired several committees, and was widely regarded by her colleagues as a consummate and tireless professional. So here you have, I mean, this is hard, right? A woman working in correctionals or any type of law enforcement field. Cute little story. I almost became a law enforcement officer before I went to college. Believe it or not, I was very close. I passed the entrance exam, and it just wasn't for me. So that's what I'm going to say about that. Believe it or not, I almost became a law enforcement officer in my area. So that's interesting. Like I said, it's what I've heard from department and agencies is that, you know, it's very hard for women to move on. It's changed a lot throughout the years, but it's very hard for promotions and it's very hard for various things. And, you know, there's kind of attitudes and behaviors towards women in correctional facilities or law enforcement. Shout out to all my female police officers out there. Shout out to y'all. Defendant Bianco was at all times relevant to the litigation, a policymaker and or supervisor, acting under color of law within the course and scope of his employment in office as the sheriff of the Riverside County Sheriff's Office. Defendant Bianco has served as sheriff since 2019. He oversees more than 3,600 employees in 5 correctional facilities. Under his leadership, the department has experienced multiple scandals, including the Riverside County Correctional Facilities becoming the deadliest jail system in the nation, which led to an ongoing investigation by the California Department of Justice. He is being sued individually and in his official capacity. So, wow, is the Riverside Correctional Facility the deadliest jail system? Do I have anybody from that area? Whoa, this is new to me. I've never even looked this up before, but this is interesting. Defendant Sharp, was at all times relevant to the litigation, acting under color of law within the course and scope of his employment and offices as a law enforcement officer of the RCSO. As undersigned Sheriff Sharp served as the second in command within the sheriff's office. He is being sued individually and in his official capacity. So, under the color of law, for those, because this is being thrown out, it means an action is taken by someone who appears to have legal authority, but whose actions are not actually supported by law or exceed their legal authority. It often refers to actions by government officials, but can also apply to individuals who misuse their position to violate someone's rights. Okay, so that's interesting. Wanted to put that definition out there so people understood that. Defendant Lopez was at all times relevant to the litigation, acting under color of law within the course and scope of his employment and offices as a law enforcement officer of the RCSO. As an assistant sheriff of corrections, Defendant Lopez oversaw the management and operation of the county's jail system. Defendant County of Riverside. Okay, so now we're talking about the County of Riverside is the other defendant. Defendant County is a duly constituted governmental entity in the state of California and is or was the employer of all individually named defendants, including but not limited to those who are sued in their individual and official capacities, as well as one or all defendants, those 1 through 10. The identities and capacities and or natures involved with defendants 1 through 10 defendants are presently unknown to plaintiff. Plaintiff therefore sues such persons using does as fictional named defendants. So what this means, for those that don't understand, is that when somebody adds like does 1 through 10 or does 1 through 5, depending on how many people, this allows the plaintiff to add other people to the lawsuit. Okay, so say that Flores says, okay, these are the individuals that I want to sue, but maybe there was another supervisor. Maybe they found out something else was happening with another supervisor, or through discovery, they find something. She's able to add other people to this lawsuit. Plaintiff is informed, believes, and thereupon alleges that there is likely to be evidentiary support to prove that Doe defendant was involved in some manner and legally responsible for acts, omissions, and or breaches of duties alleged below. Plaintiff will amend the complaint to name the Doe defendants upon learning their true identities and roles in the actions complaints of herein. So yeah, I would imagine that this would be like for discovery. You know, maybe there was an email or a conversation or something happened, and this would allow her to add more people to this lawsuit. Okay. Let's get to the facts. Facts applicable to all causes of actions. Okay. Plaintiff Flores began her employment with the RCSO on April 11, 1996. Throughout over 28 years of employment with the RCSO, plaintiff rose through the department's ranks, consistently received excellent reviews of her work, and had a reputation of honesty and integrity. Before the episode flagged as the reason for her termination, she had never been subject to any disciplinary actions. Plaintiff experienced gender discrimination, which affected the rate at which she was promoted, and retaliation in the form of termination for being unwilling to stay silent or cover up the corruption and unconstitutional practices she witnessed. Retaliation for challenging unconstitutional actions. In May 2021, while a correctional lieutenant, plaintiff became aware of an incident at the Robert Presley Detention Center involving excessive use of force against an inmate, which resulted in the inmate suffering a head injury and loss of memory. Plaintiff was shown video of the incident by one of the sergeants. She appropriately reported the incident to her superior officer, and the incident was subsequently investigated by the Professional Standards Bureau, the PSB. While the investigation was underway, Lieutenant Flores was promoted to the captain of the Robert Presley Detention Center in July of 2021. When the investigation was completed some months later, Captain Flores noted that the deputies received no disciplinary action. Flores spoke to Captain Kenneth Paulson of the PSB to ask why no discipline was issued. In response, Paulson downplayed the entire incident, explaining that there was no issue because the inmate had no recollection of the events. Listen, I don't know what the inmate did to get there. Like, I'm not defending the inmate or anything. This is that fine line where, civil liberties and doing procedures and protocols is important. If this person was supposed to be disciplined, why weren't they? And just because a person lost their memory due to the injury, they can't follow up and they can't report anything. They have footage. That's what it sounds like. Let me know what you guys think in the comments. Captain Flores posed a hypothetical question to Captain Paulson on what would have happened if the inmate would have died. And Captain Paulson responded flippantly, well, then we would have done a homicide investigation. Oh, damn. Okay. Similar incidents continue to occur at the detention facility. It was well known by her staff that she would not tolerate the use of unconstitutional excessive force. Concerned about reports of inmates' mistreatment and deaths, the Riverside County Grand Jury evaluated conditions in the county jails and prisons beginning in 2021. Plaintiff met with the grand jury for a question and answer session in August of 2021, shortly after achieving her new position, and was transparent about all her practices concerning the administration of the jails. She received a letter of commendation from one of the members of the grand jury for her forthrightness in answering their questions. When the grand jury reconvened in March of 2022 and requested another question and answer session regarding inmate's death, defendant Bianco, concerned plaintiff, would testify honestly about these incidents. Ordered plaintiff to say that she was sick so she could not appear. Hold up. Okay, let me stop. So in this paragraph 14, it says that there were similar incidences that continue to occur at the detention facility. Her staff knows, she's the captain, her staff knows that she's not down with the excessive force, okay? The inmate mistreatment and deaths that were happening at this facility, Riverside County Grand Jury got involved and they started evaluating the conditions of the county jails and the prisons, okay? So Flores meets with the grand jury. They do like a question and answer, all right? And the grand jury is like, commends her for being just transparent and being able to answer the questions, just being forthright. She gets a letter, okay? To only mention that she was promoted shortly after, right? So she's feeling good. Then we go to paragraph 15, and it says, when the grand jury reconvened in March 2022 and requested another question and answer session regarding inmates' death, defendant Bianco, concerned plaintiff would testify honestly about these incidents, ordered plaintiff to say that she was sick so she could not appear. So Bianco, aka Yosemite Sam, he's like, Flores, you need to call in sick. I'm ordering you to call in sick. Okay, so you don't appear to answer more questions for the grand jury. Okay. Unwilling to lie but concerned about repercussions from disobeying Bianco, plaintiff said she would instead take a vacation day that day. Oh, did she take a vacation day that day? That's the question. While in her leadership position at the detention facility, plaintiff quickly reported any issues to the PSB. Okay, this is that standard board. And her direct chief, including another severe incident that occurred in May 2023. The incident involved a deputy with a history of disciplinary issues. Plaintiff reported the deputy to the PSB, and Chief James think his last name is Kratchmer, and he was placed on administrative a month later after the incident. So there was another incident involving another officer by the name of James Kratchmer, okay? That incident led him to be put on like an administrative, I'm assuming leave for a month right here, okay? However, as soon as plaintiff was placed on administrative leave, I don't know if there's a typo here, the deputy was brought back to active service without receiving any discipline. So was Flores placed on administrative leave and then that deputy was brought back to active service without receiving any discipline? Or was James Kratchmer put on administrative leave and then the deputy was brought back to active service without receiving any discipline? Okay. There's a confusion there with the sentence, but I think they mean that this deputy who got in trouble in May of 2023 was put on administrative leave, and then he was shortly brought back after administrative leave with no discipline. In August 2023, an inmate suffered a fentanyl overdose and required hospitalization. Flores immediately informed her superior officer, Correctional Chief Misha Graves. Captain Flores explained to Graves that the inmate in question could possibly pass away. Chief Graves told plaintiff that she did not want to have another death listed for corrections. Graves told Flores not to send her the notification of incident, the NOI, which would have been the usual protocol. Instead, she stated that she would have the inmate federally released from custody while he was in the hospital, which would remove him from the list of incarcerated individuals and distance Graves from any responsibility. The federal release process is only supposed to be used when a detention facility reaches 90% capacity, which was not the case at that time. Recognizing the inmate's release was atypical, plaintiff sent the NOI to herself for documentation. Oh, so Graves was like, don't send an NOI, but Flores sent an NOI to herself for documentation. And it further goes. Additionally, the Robert Presley Detention Center houses many severely mentally ill inmates. Because their illness made them unable to either understand or comply with requests, these inmates frequently responded violently towards the deputies. The use of force investigation team, CAPO, began pushing for criminal charges to be filed against these inmates so that they can use those charges to argue against any inmates who filed civil excessive force suits against the RCSO. Ooh, this is interesting. So basically by filing charges against those specific kinds of inmates, they could argue against any type of excessive force lawsuits that would be filed against the facility and these officers. That's interesting. Plaintiff pushed back against this plan because it would ultimately keep the inmates in custody longer and delay or entirely prevent their getting treatment for their illnesses. Flores spoke out against this practice in October of 2023. Instead of addressing the issue 3 weeks later, leadership once again reacted by moving all the facility commanders around. Plaintiff understood that this was part of the leadership's F around and find out treatment for individuals who voice their concerns about leadership's actions. So F around and find out if you complain. It's in the lawsuit. It says F around and find out. Okay. Similar occurrences continued at the Riverside County Correctional Facilities in which inmates died or were seriously injured, and disciplinary actions was not taken against the predators. So those predators would be the officers, right? And again, Chad Bianco, aka Yosemite Sam, he's like in charge of this facility as well as other facilities, and this is all under his kind of command, right? So I kind of see him like on the top of the chain, and then everybody else, is under him. The sheriff's office covered up or hid information about these incidents from the relatives of the deceased inmates. The severity of these incidents was such that the Department of Justice initiated a civil rights investigation of the sheriff's office that is still ongoing. So the DOJ got involved and they have an ongoing investigation A motivating factor in plaintiff's termination was plaintiff's opposition to defendant's illegal actions and egregious conduct and fear that she would expose them. Oh. So did she ever interview with the DOJ about all of these actions? Listen, I'm not a fan of the DOJ as well, but anyways, I'm more of a fan of independent auditing, like on ombudsman's offices or something like that. And police typically should have, as well of any facility, they should have independent reviewers that are not funded by DOJs or the states or anything like that. Okay, anyways. Plaintiff's concerns about potential retaliation from leadership were heightened when, after the incident with Chief Graves, she found a representative from the Technical Services Bureau in her office altering her computer. Huh? So it wasn't that long ago that I stopped working in government. And when I worked in government, they gave me a computer, they gave me a cell phone, they gave me everything that I needed. iPad, laptops, internet cards, all that stuff. I had all that stuff, right? So when she says right here, Technical Services Bureau in her office altering her computer, that wouldn't necessarily be her computer. That would be the agency's computer, right? The government's computer. So they can do whatever the hell they want to. They could put trackers, they could put all kinds of things because it's their property. So this is interesting, unless this is a personal computer, which I don't think that's the case. But anyways, let's continue reading. The representative claims that it was to enable plaintiff to make Amazon purchases for her facility was nonsensical, as purchases of that type were handled by someone else. Suspicion about the real reason for the representative's actions, plaintiff examined her computer settings and found that a second IP address was now associated with her system, suggesting her computer was being mirrored and monitored elsewhere. Okay. How did she find this out though? So she was able to find a second IP address? I mean, I know that there's a way you can get multiple IP addresses. At least I've heard, okay? I've never done it, but I mean, there's like VPNs that allow you to get different IP addresses and stuff like that, but it's interesting. Okay, let's keep going. Plaintiff was terminated in part because defendant Bianco knew plaintiff recognized and would expose the egregious wrongs occurring in the jails. Okay, so I hope that they tell us what exactly happened here. Retaliation for challenging corruption over charges. Beginning in July of 2021, plaintiff noted improper charges in the budget she was responsible for overseeing. These included charges for consultations she was unaware of and wildly inflated charges for construction and repair work. In September of 2021, the manager of the security electronics company, CML, contacted plaintiff. Plaintiff had developed a relationship with the vendor while working out contracts and hiring vendors before her July 2021 promotion to captain. The manager informed plaintiff that Assistant Sheriff Robert Gunzel was bringing over people from Orange County and having the contractors markedly inflate the contract prices. Shortly after this interaction, a sergeant working within the project management office, the PMO, approached Flores with concerns that Assistant Sheriff Robert Gunzel was bringing his friends from Orange County over as part of the job order contracting JOC program. He explained that of the 9 JOC contractors hired, only 2 were not from Orange County, and the other ones from Orange County had a personal relationship with Gunzel. This sergeant also expressed his concern that Renan Tedros, the director of the PMO, told his staff that he did not want any facility commanders receiving line items cost for projects to provide only the total amount to avoid raising too many questions. Oh, okay. At the time of these conversations, plaintiff was still on probation in her new position and worried about repercussions of reporting the malfeasance. Plaintiff encouraged the manager to go to the auditing company and seek an investigation and told the sergeant he would let his chain of command know. In May 2022, Lieutenant Rafael Gomez, who had some construction experience, compiled a spreadsheet of department construction's expenses and noticed discrepancies among hundreds of thousands of dollars. Gomez, oh man, this is just crazy. Gomez contacted the vendor for clarification, but the vendor refused to supply any documentation. Gomez sent the information up the chain of command, but nothing was done about it. Plaintiff, along with others concerned colleagues, appropriately practiced these charges. Instead of receiving appropriate response from the leadership, Plaintiff was told to stop challenging the charges. When Plaintiff questioned Chief Graves about a consultation fee for more than $60,000, Plaintiff was told it is what it is and received no further information. Commanders had previously been able to see and question all line items for their projects, but RCSO leadership stopped when Plaintiff and her colleagues raised concerns about the inflated or unexplained charges. Plaintiff received an email from Chief stating that Ramon Tadros, the director of Project Management Office, would no longer be providing the information. From then on, Plaintiff was only informed of the total project costs and was denied information about the components costs. Additionally, Bianco had Gomez transfer and specifically order someone without construction experience to be into that position. Gomez was told he was being transferred because he had been asking too many questions. Plaintiff was terminated in part to stop her questions and prevent her from exposing these overcharges. Okay, so and it further goes. Retaliation for challenging corruption, cover-ups for leadership. In May 2023, there was a homicide investigation in Riverside County involving the killing of a young woman by her boyfriend. The homicide investigator submitted the case to the Riverside District Attorney's Office for prosecution without discussing it with the homicide investigator or the victim's family, and in conflict with his obligations as a law enforcement officer. Assistant Chief Delgado wrote to the DA and asked him to be lenient with the perpetrator, who was a family friend. He also advocated for the perpetrator's expedited release from plaintiff's facility. Based on Delgado's letter and without the input or consent of the homicide investigator, the DA lowered the charges from murder to involuntary manslaughter. When the homicide investigator became aware of the back channel actions and changes in the charges, he demanded an investigation. The PSB came to plaintiff's facility to investigate the charges and spoke with one of plaintiff's lieutenants. Knowing the underhand actions would anger plaintiff, the PSB personnel told the lieutenant not to let his superior officer, Captain Flores, know what had happened. So I'm trying to understand this. There was a law enforcement officer who wrote a letter on behalf of this perpetrator to the DA, okay? And he was asking him to be lenient because this perpetrator is a family friend. And so all of this like backdoor stuff was happening, and this detective who's investigating this homicide was not aware of all this backdoor stuff that was happening. Okay. Now I do wonder, do we have a letter here as a exhibit? Because I need more information, right? Like at this point, how all of this relates to, Captain Flores, unlawful, retaliatory termination, and what exactly is going on. I mean, how does Flores know about all of this? That's what I want to know. Because this is a different area. She's over here in prison and correctionals, it sounds like, but it's a different area. Okay, let's keep going. Knowing the underhanded actions would anger plaintiff, the PSB personnel told the lieutenant not to let his superior officer, Captain Flores, know what had happened. Uncomfortable with these subterfuge, the lieutenant informed plaintiff of what occurred. Initially, Delgado suffered no consequences. Delgado was forced to resign only after the information got out and was met with public outrage. This really did happen? Wow. Okay. If you guys are in the area and know about this, put it in the comments. Let me know. In November of 2023, a sergeant came to plaintiff with information that one of the Harry's station sergeant was participating in I can't say the word because we will get flagged, but it's prawn por, y'all know what I mean, for payment. So prawn for payment, and I'll zoom in so you guys can see that word. Plaintiff knew the department had previously placed another correctional lieutenant on administrative leave for making a racial joke while participating in a non-prawn TikTok video, recognizing that Perry Station Sergeant's prawn video was significantly more offensive than that created by the other correctional lieutenant. Plaintiff brought the information to Chief Misha Graves. Graves made it clear that she was displeased that plaintiff raised a concern. Although Graves asked plaintiff to send whatever information she had, it ultimately became clear to plaintiff that the sergeant's prawn activities were already known to the department for a year. Instead of being reprimanded like the other correctional lieutenant, the involved sergeant had simply been told to keep it on the down low. I mean, so there was a prawn TikTok video. It's crazy. 2 weeks after bringing the information to Graves, plaintiff was placed on administrative leave. Oh. By discharging plaintiff, the department had in effect resolved the complaint because without a complainant, there was no requirement to investigate. The matter was dropped and there was no repercussions for the video participants. Favors for Bianco political supporters. Oh, this is going to get good. Okay. Favors for Bianco's political supporters. Let's get into this. Because I know this guy was trying to run for office and whatnot. And some of you guys left me some comments about that in the videos. So let's go into this. In July of 2023, a friend and political supporter of defendant Bianco's, who was the proprietor of a company called One Day Wraps, was awarded a lucrative contract to wrap several buses before any other businesses was even allowed to bid on the contract. After One Day Wrap had already completed the work, one of the plaintiff's lieutenants, Lieutenant Rafael Gomez, was told by Chief Zach Hall to justify the contract by finding 3 other quotes from other vendors that were higher than the amount paid to One Day Wraps. The lieutenant could only do so by seeking vendors outside of Riverside County. Plaintiff was not informed of the lieutenant's assignment until after the lieutenant had already completed the task. Plaintiff was intentionally kept uninformed because defendant Bianco knew she would have challenged the improper conduct. How does this feed into the political stuff? Because it says right here, favors for Bianco's political supporters. Firing range incident. On November 27, 2023, plaintiff received a call from Chief Graves stating that she was being moved from Robert Presley Detention Center to the Smith Correctional Facility. Other correctional commanders were also to be moved between facilities. On November 28, 2023, plaintiff, along with other correctional commanders, met with Assistant Sheriff Lopez to inform him that commanders did not want to be relocated. The commanders wanted to speak with defendant Bianco as they believed the transfers were in retaliation for their speaking up about leadership resistance to their filing charges and use of force incidents. Furthermore, the commanders recognized that by relocating them to different facilities, leadership aimed to prevent them from answering questions during the upcoming DOJ's investigation into the previous jail incidences because they would lack knowledge of past incidents that occurred in facilities to which they would be assigned. No meeting with Bianco was permitted. Okay. So November 29, 2023 was plaintiff's first day back in the office after having been off for several days. There was a large stack of paperwork on her desk that needed to be addressed, particularly with the pending transfers. Additionally, plaintiff wanted to arrange for 2 of her command staff members to move to the facility with her and needed to make phone calls to accomplish this. Plaintiff received a text message from Correctional Lieutenant Gomez the day before reminding her and others that they were scheduled to do a qualification on November 29th. The message did not state whether it was a daytime or nighttime qualification. The plaintiff felt that there was no time to do the qualification that day with anything else she needed to accomplish, but her team convinced her to go to the range for the qualifications. At the range, plaintiff had a new ballistic vest that she had never worn before. The vest was too large for her torso, and after shooting, she had difficulty figuring out how to holster her gun appropriately with the vest on. Sergeant Kelly, the range master, gave her commands to assist her in the process. As he was doing so, plaintiff heard Deputy Beltran yell, You, come here. Something a deputy would never do to a much higher ranking officer like plaintiff. Indeed, Beltran contemptuously pointed to the ground in front of him, essentially summoning plaintiff over to him as one might call a dog. Standard procedures would have required Beltran to inform Range Master Kelly about any concerns he had so that Kelly could address those concerns with plaintiff. Unaware of why Beltran called her over, plaintiff assumed that it was related to her being outspoken about the many issues that she had raised and that perhaps she was about to be terminated or that someone had died at her facility. She was focused on these concerns and therefore confused and taken aback when Beltran stated he called her over because she was being unsafe with her weapon when she was trying to holster. Plaintiff was confused by Beltran's aggressive attitude, which was far beyond that call for basis on the severity of the claimed offenses. Standard protocols would have been for Beltran to speak to Range Master Kelly about his concerns and have Kelly address them with plaintiff since Kelly was already dealing with the difficulty with holstering the gun. After plaintiff walked back to the bay where her team stood, she overheard a conversation between the range master in the adjacent bay and Sergeant Kelly, in which Kelly stated that an email was going out the following week, noting that the qualifications were night qualifications. Plaintiff had not realized the qualifications was supposed to be a nighttime qualification until that time. Plaintiff asked Sergeant Kelly, "Are we all right qualifying today?" Sergeant Kelly looked at the conditions and said it was fine because it was overcast. Okay, let's keep going. Embarrassed and rattled by the humiliating treatment she received in front of her team, plaintiff wanted to leave the range as quickly as possible and regain her composure. As plaintiff was leaving, she approached Kelly to say goodbye. She did not ask Sergeant Kelly to speak with Beltran, but having witnessed Beltran's unprofessional conduct towards plaintiff Kelly, called Beltran over of his own accord. Beltran and Kelly proceeded to get into an argument over what just happened. When plaintiff witnessed Beltran also being disrespectful towards Kelly, his superior officer, she told Beltran his behavior was inappropriate. However, because plaintiff strongly believed in leaving any interaction on a positive note, she told Beltran that she had heard good things about him and she looked forward to working with him at the Smith facility. Furthermore, as she was leaving, plaintiff asked Kelly to check on Beltran and ensure he was okay. In the investigation that followed the incident, Beltran misconstrued plaintiff's act of good faith as an attempt to intimidate him. Plaintiff, as per usual practice, did not fill out the qualified time on paperwork. Sergeant Kelly completed the paperwork. Plaintiff left the range without recognizing Kelly falsified the time. It was not unusual for RCSO officer to qualify slightly earlier for nighttime qualifications than 5 p.m. because they cannot receive overtime pay to come to the range after hours. Based on the incident at the shooting range, plaintiff was placed on administrative leave in December of 2023. Plaintiff was charged with falsely stating that the qualifications was a nighttime qualification when it was done during the daylight hours, and for conduct unbecoming of an officer related to plaintiff's questioning the matter in which Deputy Beltran reprimanded her at the shooting range. These charges were false. However, even if true, they would not have been brought against a sheriff's office employee with an impeccable record were it not for a retaliatory purpose. Okay, then we're going to get into the gender discrimination. Starting 3 years ago, defendant Bianco and RCSO leadership denied plaintiff's promotion that were promised to her and for which she was the most qualified. 4 men received promotion ahead of plaintiff. The delay in promotion impacted plaintiff's ability to move up the ranks to chief. Subsequently, even though plaintiff was highly qualified for a chief position, she was passed over by a less experienced male colleague who was one of the 4 men who had been promoted to captain ahead of her. In November of 2022, RCSO Lieutenant Thomas Tanner attempted to further degrade plaintiff by breaking into her office and placing multiple photos showing Sheriff Bianco winning the recent election throughout her office. Lieutenant Tanner, who had a history of treating women disparagingly, would not have acted similarly towards a male colleague. Plaintiff. Additionally, when Captain Flores reported the incident, it was not investigated. Plaintiff willingness to protest discriminatory treatment is one of the reasons she was retaliated against. RCSO has a known history of using derogatory terms to describe women. Women are generally categorized as witches, it's the B word, or luts, it's the S word, and treated accordingly, whereas a male officer would be raised as a strong leader at RCSO. Plaintiff was categorized as a witch for demonstrating the same leadership qualities as male leaderships in the department. This classification was used by witnesses to impugn plaintiff's character during the shooting range incident investigation. A man in her position would not have been terminated. Plaintiff male colleagues who were fired at the same time were the collateral damage of the RCSO leadership actions against plaintiff. Okay, then we go to the termination. Defendant Bianco used the shooting range incident as a pretextual justification for plaintiff's termination. In the termination letter dated April 26, 2024, defendant Bianco noted he reviewed Flores's employment file covering the previous 5 years period and found not a single incident of prior disciplinary actions. Nevertheless, he proceeded to terminate her employment. Plaintiff was terminated from her position on July 11, 2024. Had plaintiff been a male and unquestioning of defendant Bianco's misconduct, a single disciplinary action over a decade of service would not have led to the termination of a respected 28-year veteran of the sheriff's office. At the same time of her termination, plaintiff was a commander at the Robert Priestley Detention Center. On January 8, 2025, plaintiff timely filed a claim against the county of Riverside regarding her wrongful and retaliatory termination pursuant to Government Code 910. The Riverside County Board of Supervisors denied the claim on January 14, 2025. On February 18, 2025, plaintiff timely filed a complaint with the California Civil Rights Department and received a right to sue notice. On March 11, 2025, plaintiff timely filed a complaint with the EEOC. To date, the EEOC has not issued a right to sue letter. Plaintiff will amend her complaint when she receives a right to sue letter or 6 months have passed. As a direct and approximate result of defendant's actions, Ms. Flores continues to suffer severe emotional injuries and medical expenses. Her future earning potential have been irreparably harmed by her removal from a government position she led for nearly 3 decades. Okay, so then it gets to the claims of relief, which we're not going to get into, but it just between the first, the second, they start listing out all these claims. Now, it doesn't say the sum, but there is no sum listed for this lawsuit. This was filed by a legal office, so the names are right there. I think his name is Paul Hoffman, the attorney who's part of this LLP, and this was filed July 7th of 2025. Now, what we know so far is that people have been served. I don't see yet that they have a court or a hearing date yet on this, but it is out there. Actually, you could find this filing on Justia Flores versus Chad Bianco and the Sheriff Riverside ETAL. You could actually find this filing there. So again, exposing the sheriff for various things. There's certain aspects of this lawsuit that I'm a little confused about, like, these are just allegations, right? So they're going to have to go to court. What is discovery going to look like? I mean, what do they have to show for the things that the allegations that she's making, and what is going to happen next? But if you search Chad Bianco, he's got a lot of lawsuits out there from people in the department. So to me, it kind of makes me wonder, has there been any disciplinary against Mr. Chad Bianco and associates? Let me know what you guys think about this lawsuit. And if you've never heard it and you're in that area, let me know what your thoughts are. Make sure you guys share this video because it helps spread the word about this lawsuit. I'll see you guys in the next one. Rabbits out. Bye, guys.